right, with any luck, Nancy, I'm live. Okay, hello everyone. I was experiencing some technical difficulties, so I'm just curious if there's anyone on there. If you could just type "I'm on," so I know that it's working. I'd appreciate that. Okay. Let me just make sure our settings are good. I'm good. Okay. So anyway, I apologize. My name's Craig Andreoli, and I'm an elder law attorney. And one of the things of our topic today is new Medicaid laws and rules that are in effect. I had a PowerPoint presentation all scheduled and ready to go. Unfortunately, I lack the technical ability to show you my PowerPoint, but I will do my very best to kind of walk you through this new topic. So Governor Cuomo passed a new law into effect that starts on October 1st of this year. And it basically is adding a 2.5-year look back for community care services under Medicaid. So previously, Medicaid community care, which is having aid come into the house and taking care of you with activities of daily living that you might suffer from, like walking or cooking, cleaning, ambulating, or if you have dementia. So the old rule in New York State was that there was no look back towards if you gave away assets to become eligible for the program. Medicaid is a resource and income-based welfare program. So to be eligible for that program, you have to have less than $15,750 of total savings, and then there's an income contribution. So before you are actually eligible for Medicaid community care benefits, you have to be below that threshold. So if I have $200,000 and I need to get down to $15,000 and change, one of the easiest way to do it is to give it away. And up until this new law, Medicaid was completely fine with that. They didn't have any look back. You simply gave away your assets in January, and February 1st, you would be eligible for Medicaid benefits as long as you met all the criteria of disability and you were below that $15,000 threshold. So with the new law coming October 1st of 2020, the Medicaid community care look back is being extended from basically nothing to 2.5 years. So first of all, if you were kicking around putting a house in trust or filing for a community care Medicaid application, doing so before October 1st, if you're over-resourced, would not be a bad idea to do, considering after October 1st, there's going to be this look back. Now, while the statute doesn't clearly define the start dates and end dates for the look back, there's a bill that is pending, and it's very promising that they think it'll probably be phased in. So October 1st, there'll be this look back of 2.5 years, but if you filed for Medicaid on November 1st, they would look back 1 month to October 1st. And then in December 1st, it would be a 2-month look back. And it'll phase it in until 2.5 years out. It will continue to go back to October 1st, 2.5 years later. So every month, they're going to add a month until the 2.5 years has been instituted. Again, so what does that mean? That means a lot of good things if they actually come down with that decision, which seems very likely. And that is that you're going to be able to gift assets, preserve assets, and file for community care Medicaid prior to October 1st with no issues. You'll be grandfathered in. It would be very heavy-handed, I think, that if you had a law that started 2.5 years right away from October 1st, there would be a lot of people who had legal transfers and got onto the Medicaid program with no issues, all of a sudden being penalized and being thrown off that program because of this new 2.5-year look back. So that I don't think that's going to happen. This is also the way they handled an extension of a look back in chronic care. So if you needed nursing home care, the current look back is 5 years. Prior to that time, 2006, it was only a 3-year look back. So when they went from a 3-year look back to a 5-year look back on chronic care, nursing home care, they phased that in as well. each month it was another look back until the full 5 years was in effect. So that's the big news. So what should you be doing, and what are things that we're concerned about? Well, first of all, like I say, if you're on the cusp of needing community care services, you're missing a step, and you feel that you can't privately pay for these type of services, you're going to need to concede that maybe Medicaid is a form of insurance that you're going to require. And Medicaid, while they'll pay for such services, there are these recovery laws, and there's also this threshold of resources and income. So the very first thing you want to do is perhaps preserve large assets in your portfolio that you don't need to live on. The house is typically the house is usually fills that bill. Most people that are filing for these services, they don't need a line of credit or tap into the equity or sell the house to get through their retirement. Their plan is to keep the house in place. They have enough income or savings already generated that will give them the lifestyle that they so choose for throughout the retirement. So if the house is something that you really don't need the equity in to survive throughout retirement, then it might be a nice asset to try to preserve. And when I say preserve, I'm talking about preserving it from Medicaid recovery and future creditors. So one of the tools that we use are irrevocable trusts. And the concept behind an irrevocable trust is you take your house and you disown it, which sounds frightening, and you place it into an irrevocable trust. Usually children are your trustees, and it's not the child's property at that point. What we try to do with the home is we give you every ownership right we possibly can give you with the house. So for example, by granting a life estate, which is drafted right into the terms of the trust. And what this life estate says is that my trustee child, or whoever you want it to be, cannot kick me out of my house. They cannot charge me rent. They cannot sell my house without my consent. I want to continue to keep my enhanced STAR benefits or my veterans exemptions and from real estate taxes. So all of those you get to keep. And if you even rent the house, you're entitled to the rental income. So those are all the positives that this life estate will grant you. The cost of getting those benefits are that outside of the trust, that the creator of the trust has to pay for the real estate taxes, the homeowner's insurance, and maintain the house. That needs a new boiler, you get the new boiler. If it needs a new roof, you get the new roof. We don't need trustee permission or anything like that when you're doing the maintenance. It's just assumed you're going to take care and maintain the house. All the things you're probably doing already. So for people who put these houses in trusts, they don't feel any realistic change in their life. If I didn't tell them their house was in trust, they wouldn't even know it because really nothing changes in terms of full use of the house. And then if you even decide to sell the house, you have the right to do that. So what we usually do is you ask your trustee, you tell them, hey, look, I want to downsize. I want to move to a smaller location. And the trustee will sign the paperwork required to sell the house. And so let's say your house is $400,000. So this $400,000 when they sell the house remains in the trust. And then you can do a few things with the $400,000 in my example. First is you can buy a smaller place using it. So the trust will purchase a $300,000 house. And now you have a smaller house in the trust and $100,000 in a savings account that's associated with the trust. That savings account can be mutual funds, bonds, savings accounts, CDs, any investment you want, other than retirement investments like IRAs. So once you have that, you've gotten your new house, it doesn't disrupt the 5-year look back. So even though I asked my trustee to sell my house on the 2 years into the plan, it's not like the 5-year clock resets, or in this case, the 2.5-year clock resets. Once it's in trust, you're allowed to swap equal value in and out of the trust. Now, you may want some portion of that $100,000 in my example. You want to take the family on a cruise around Australia, okay, and you want $30,000. One way of getting that $30,000 out, if it's okay and a provision I can put into the trust. And every provision is not right for every person, but I am trying to give you an example of some flexibility of how these trusts work. And that is simply you ask your trustee child usually to take an early inheritance of, say, $30,000 to pay for the trip. They put it into their personal bank account, and then there's nothing that says a child can't give money to you or pay for that trip directly. And that's how we get money out of the trust. And there's no tax consequences to that. So $30,000 deemed a gift or an early inheritance, and then a turnaround, and that child gives it back to the parent. Now, gifting laws, you can gift $11 million tax-free. In my example, if it was $30,000, you don't even have to report the gift back because you're allowed to give $15,000 per person per year without having to report that gift to the IRS. So maybe $15,000 to mom, $15,000 to dad. They now have their $30,000 to pay for their trip. So there is a way to get principal out of the trust, but there's one thing you can't do with these trusts, and that is have a trustee cut a check directly from a trust account to the creators of that trust. So in my example, mom and dad, that should never be done. Now, you can also, let's say you don't want to take the $100,000 out, but you could use some supplemental income. Well, you can invest that $100,000, like I say, let's say it's tax-free municipal bonds. Every month, we have an automatic sweeping of income to come out of that $100,000 and deposit it directly into the creator's bank account. Now, income is not principal. Income we can take right from the trust and give it right to the creators, again, if they're comfortable with that type of arrangement. You can also just let the income roll over in the trust, or you can have your children be income beneficiaries. So there's a lot of options in there depending on whether you want that income or don't want that income. Now, let's say you have a situation where your trustee / child does not want to sell the house, but you do. It doesn't happen often, but when it does, that is solved pretty basically by firing that trustee and putting a person in place that would be more in line with your thinking, which is to sell a house. You don't have to cut that person out as a beneficiary, but if they're not doing what you want, you may want to replace them with someone else who will. So these trusts, even though they're irrevocable, they do have a lot of flexibility. The new laws that Governor Cuomo passed also, I should say, the statute is out there. The law has been passed. It's effective October 1st. There's been a pushback of the start date to January 1st, but I don't want to confuse things. All gifting or transfers should at this point still be done before October 1st. And then they also had changed some of the medical aspect to it. So to receive Medicaid, you have to suffer from 2 or 3 activities of daily living, depending on whether you have a cognitive impairment as well. They are making it more difficult. Now, there is no definition of activity of daily living, believe it or not, in the Medicaid laws. So, but we kind of understand how the state and counties have been determining it. But they're going to kind of bump that up a little bit. So now they have to actually have physical need to transport. So if you were just staggering a little bit, you now physically have to move your leg. You know, it's a higher standard, but it's still the activity of walking or mobility. So there's a bunch of things that are going on just with the care level that are also been instituted with the new law. So we can expect to have a little bit more difficulty in getting adequate hours, perhaps. But time will tell how that pans out. Right now, though, fasten your seatbelt. The changes have to still be interpreted by the Department of Health. So we're waiting for their determination, which has not come down as of yet, to say, yes, we're going to be phasing it in. Yes, we're going to be doing this. Yes, transfers to the House are or are not acceptable even within a 2-year period. So there's a bunch of things that need a little bit of clarification. I was hoping to have that information for you for tonight. It's just that the Department of Health didn't decide to cooperate with me today. Now, there are some other things you should know about community care and transferring protecting assets. They have not removed the concept of spousal refusal. So if you have a spouse, and one of you needs Medicaid, community care, or nursing home care, we still have the ability to make a transfer between spouses, and that will not disrupt any look-back periods. The concept behind that is if nothing's done after the second spouse receives the assets, Medicaid has laws on the books where they can still pursue and go after those assets when they're both gone. So it is a two-step plan, though, but we can get Medicaid for one person immediately by simply doing transfers of assets to spouses. There's also an exception for disabled children. So if there's any silver lining in a child with disability, if they can receive money without disrupting whatever benefits they may be receiving, then we have another option where we can transfer assets to this disabled child and again, not interfere with the look-back period. So these tools are still in place. Spousal refusal, I said, is where we transfer to a spouse and then we file the spousal refusal to be sure that the income and resources of the well spouse are not considered when making a determination of eligibility for the applicant. Now, they are allowed to see what both spouses own, but they can't take that into consideration when determining eligibility just for the applicant. And that's a huge tool. We're one of the few states that still has spousal refusal. You may have heard in the news from Newsday, 29 times it has been brought up to end it, and 29 times it has failed. So still here in New York, and it's a good tool to make sure that people can stay at home, get Medicaid, and still preserve some assets so they have a pool of money to dip into to enhance their quality of life, to leave a legacy, or to make sure a spouse is being taken care of. So these are all still good things that the new law has not affected. The other thing that was not affected are pooled trusts. I told you Medicaid is a resource, meaning you have to be poor, and they have an income contribution. So the income contribution this year is $875 every month of your income you get to keep. And if you are of a certain age, you get an additional $20. But the rest they want to give to the managed long-term care company for reimbursement of services, meaning the people who are providing your aids, they want all your excess income to go to that agency to help pay for those services. One way to get around that law is to tell Medicaid, and they accept this, as do the managed long-term care companies, and they say, look, this excess resource I have above $875, I don't want to give to the company providing my aids. I'd much rather give it over to what's called a pooled trust. And it's usually a charitable organization, not-for-profit, and they run these pooled trusts, some of them. And what they'll do for a service fee is receive your money and then turn around and pay bills in the applicant's name. So let's say my total income is $1,875. Medicaid lets me keep the $875, and I'm supposed to give away the $1,000 to the company providing the aids. Well, instead of doing that, I get to say, no, you don't get it. I'm going to give the $1,000 over to this pool trust company. They may take out $150, $200 a month, but you will be able to then apply the remaining $800 towards bills in your name, mortgages, homeowners insurance, real estate taxes, utilities, cable, car insurance, whatever it is. So we have a way to preserve the majority of excess income, and that is still in play. So we still have a myriad of tools to make sure that people can age at home, where most of my clients want to be, to make sure that they have a quality of life, that they have help that they need, so a spouse can continue to be playing the role of a spouse and not the role of a caregiver or a child. It gives these caregivers a break, which is really is important also, because if you are a caregiver, you know just how difficult that position is, and any chance to get a little respite, comes with guilt and all sorts of emotions. But if there's a payment source and there's help that can be put into the house, I think many of us would consider tapping into that resource. But we do want to preserve assets and make sure that that help is paid for by the government if that's appropriate. And in many cases, it is. So you'll be able to have those type of services instituted even under the new laws. The main thing I think that we have to watch out for is pre-planning becomes even more important with a 2.5-year look back. I can't tell you how many families miss the opportunity, even with no look back, where mom just keeps getting worse, but they don't want to see it. They want to believe she's better off than she is. No plan is put into place, and then something drastic happens. They walk in, she's living with 15 cats, the place is a mess, the bills haven't been paid, and then they move into action. And at that time, oftentimes it's too late. They cannot even sign paperwork or legal documents because they don't have capacity. They may have to start a guardianship. Well before or at the first signs of any sort of certainly mentally related deficiencies, you want to make sure they have proper documents in place. Foremost, in my mind, the document to take care of them while they're alive, but beginning to miss a step, would be the power of attorney. It's the power of attorney and the way a power of attorney is drafted that would allow us to preserve their income or make big transfers that we legally don't have the right to do without authority from the person. And the person needs to have legal capacity to sign that document. So very important to plan early these days, because both home care and nursing home care have this look back, and private monies are very exposed if the plan isn't put into place sooner than later. The other important one, of course, is a healthcare proxy. And what I really like, and I got into this business because my grandmother had 12 years of Alzheimer's and basically lost all her wealth to her own care, leaving my great aunt in a bit of a lurch. But anyway, the concept behind excuse me, and I apologize, no PowerPoint. So if I had the PowerPoint, it might have been a little bit more clear. I hope that I am at least laying out these concepts with some clarity for you guys to follow. But anyway, getting back to planning, the important planning is the power of attorney, and then the healthcare proxy. So if they can't direct their own healthcare decisions, we want to make sure the right people are making the right decisions. And again, that document needs to be signed well in advance of them losing capacity. And we want, especially if it's outside kind of a natural statutory pecking order with a spouse, then child, and whatever. So if you've got 3 children, healthcare proxy will define which one is really the one that we should be listening to and directing healthcare. If it comes to end of life, living will is also very important. It's the New York's legal proof that if your family, friends, and physicians are all talking about pulling the plug, you have confidence that their decision is the right one, and you vote that pulling the plug is appropriate for you also. And these things have to get done prior to, again, diminished capacity. So the will, of course, is significant in making sure that the assets are distributed in the fashion you want, but it will say that a main asset that goes through your will is usually your house, and if you set your house up into a trust, that will avoid probate, and your will becomes a little bit less important, or at least distributes a little bit less property, which is convenient for your family, and it's usually a little bit more a savings from the costs that attorneys charge to probate the will. So that trust also has that ancillary effect of avoiding probate. So I don't know if there's any comments or questions. I'm wrapping it up, and if there are, feel free to contact me or shoot me that note now. Otherwise, I just want to leave you with the concept that the new law is forcing planning to be done a little bit sooner than we would like. So pre-plan, talk to your attorney, and make sure that you're covered and with the proper estate planning documents in place. In this field, I think it's important to make sure that you do someone who only practices in the field of elder law and estate planning. Sometimes, like a power of attorney drafted by someone who doesn't know all the Medicaid laws, falls short of giving the authority we would need to save income or transfer assets and save those assets as well. So thank you for your time. And my name was Craig Andreoli again, and I can be reached at 631-686-6500.